Major United States Supreme Court news, but it's not obvious to the unobservant of Supreme Court practices. There has been a cultural change in favor of self-defense at the Supreme Court. I'll break it down for you in one moment. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gunner, a constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner, please do so. We're trying to get to 100,000 subscribers as fast as we can to help us with the algorithms. Okay, so today, big news out of the United States Supreme Court, though it's not obvious. I have here the 2022 year-end report on the federal judiciary. And you're like, Mark, why on earth would I want to read such a geeky government document, such as a year-end report on the federal judiciary? It's because of what it says. Who wrote this? Who signed it? Who published it? The answer is Chief Justice John Roberts of the United States Supreme Court. Now, what did John Roberts decide to write about in the 2022 year-end report on the federal judiciary? He could have written anything he wants. He is the head of the federal judges, all the federal judges. John Roberts is the boss as the Chief Justice of the United States Supreme Court. And what does he choose to write on? And this is very important. He chooses to write on the importance of physically protecting judges in the United States. He talks about the importance of having the U.S. Marshal Services and other federal agencies protecting the judges across the United States, including Supreme Court justices, from people that would do harm to their lives. And he explains not only is this important, of course, to the judges and their families, that's obvious, but it's also important to the integrity of the judicial system, where we can disagree about outcomes, we can disagree about who should win or lose cases or what certain things about the law mean, but we should never feel or believe that the integrity of the process has been violated because someone feels intimidated to rule in one favor. That's the sort of thing you see in banana republics, where judges are intimidated by mob rule, or they're intimidated by cartels or by gangsters or something that rule in a particular way. We don't want that in the United States, because then we become a rule of men instead of a rule of law, and we don't want that. The reason why I think this is so important for the Second Amendment, by the way, is because here you have, and I'll tell you why it's so important that John Roberts, Chief Justice John Roberts, wrote this. We'll talk about the history of John Roberts in the Second Amendment in just a moment. But he specifically talks about how, going back to the civil disobedience in the civil rights era, the 50s and 60s, about how states were trying to violate the Constitution, and they were trying to violate federal law, and they were trying to violate the court orders by the U.S. Supreme Court. And he talks about the importance of the judges and others in the community standing up to states and state officials that thumbed their nose at and sought to violate the Supreme Court's decisions. Sound familiar? Do we know any states that might be trying to violate and do harm to the decisions of NYSERPA versus BRUEN? I think we do. So John Roberts, and I'll put a link to this report down below, talks all about this, and he specifically says he says that the judge, and this is what he brags about and boasts about, he says that the judge down in Arkansas, Little Rock, Arkansas, that was involved in one of the major cases involving desegregation, he talks about Judge Davies. And he points out that Judge Davies was physically threatened for following the law. His wife feared for his safety. The judge was uncowed, and happily so were others who stuck up for the rule of law. Not just with regards to the judge, but to even greater threats against the school children, their families, and leaders like the NAACP's Daisy Bates. He says that there was a bomb threat with a hotel where the judge was staying for a period of time, and the hotel did not kick the judge out or ask him to leave. They basically kept the judge there. So essentially, John Roberts is acknowledging that judges have been physically threatened over the years, and it's very important to keep them safe. John Roberts then goes on to talk about how he wants to thank members of Congress who are attending to the judicial security needs with funding of them necessary to run a system of courts. Justice Roberts also talks about a Judge Esther Salas, a United States District Court judge in New Jersey, whose son was killed in an attack. The guy who killed the son was actually apparently looking to kill the judge, but the son answered the door when the criminal came to the door. And then, of course, John Roberts, in this year-end report, thanks the U.S. Marshals, court security officers, federal protective service officers, Supreme Court police officers, and their partners who are on duty as we ring in the new year, working to ensure that judges can sit in courtrooms to serve the public through the coming year and beyond. Now, you may ask me, Mark, why should I care as a supporter of the Second Amendment that Chief Justice John Roberts just wrote this very long report that focuses on the physical security of judges and the judges' families in the United States? Well, we know at first glance why Chief Justice Roberts wrote this. We know that there was an attempt of an assassination on Brett Kavanaugh, Justice Brett Kavanaugh, after the Dobbs abortion decision was leaked. We know that there have been people protesting outside Supreme Court justices' homes, which is arguably a violation of federal statutory law, but no one's been indicted or prosecuted by the Department of Justice. We know this has all been going on, and there's been all sorts of calls and threats against the Supreme Court because people are not happy with some of the decisions that they've been coming down on, everything from certain voting rights issues to gay rights to Second Amendment issues to abortion questions. So we know that the Supreme Court is currently constituted as under a lot of pressure, and that is largely intentionally so because they're trying to get the Supreme Court to change their views on certain hot-button issues. But it doesn't appear as if that's going to happen based on what the Supreme Court is taking and hearing. But here's why this all relates to the Second Amendment. Now, with this context, this is what's going to separate you from everyone else when you talk about these issues. So here we have Chief Justice John Roberts is writing about the importance of physical security and having all these different federal agencies with guns, of course, protecting Supreme Court justices and their families, which, of course, they should be protected. We 100% agree with that here at the Four Boxes Diner, that these judges should be protected and their families should be protected. 100% should happen. So why should we care about Chief Justice John Roberts' words at the end of 2022? It's because let's put this into some historical context of just where John Roberts' head was when it came to the Second Amendment's right to keep and bear arms. Yes, it's true that Chief Justice John Roberts was in the majority opinions in Caetano, in Heller, and McDonald, and that was great. But remember, if you go back to 2017, this is important. In 2017, you're going to see how it all connects up in a minute. You go back to 2017, there was a case before the United States Supreme Court up on cert, which means people had requested that the Supreme Court take a case out of California called Peruta versus California, involving a concealed carry issue. Basically, a version of NYSERPA versus BRUEN, except it occurred and went up to the Supreme Court in 2017. In the Peruta case, they denied cert, which means even though in California they were violating the Second Amendment, the Supreme Court refused to hear that case. They denied cert. But justices who wanted to hear the case are permitted to dissent from a denial of cert, which is what happened. Clarence Thomas dissented from the denial of cert on the basis that he thought that the Second Amendment's right to keep and bear arms was being violated by California, and it was wrong that the Supreme Court allowed this to continue. But here is the key thing that Clarence Thomas wrote. Tell me if this is starting to ring true. Now, this is in 2017. 2017, Clarence Thomas, Neil Gorsuch dissenting in the Peruta case. Tell me if some of this sounds a little bit familiar with what you just heard from Chief Justice John Roberts in December of 2022. Here's what Clarence Thomas writes. For those of us who work in marbled halls, guarded constantly by a vigilant and dedicated police force, the guarantees of the Second Amendment might seem antiquated and superfluous. But the framers made a clear choice. They reserved to all Americans the right to bear arms for self-defense. I do not think we should stand by idly while a state, in that case California, denies its citizens that right, particularly when their very lives may depend on it. I respectfully dissent. Close quote. Clarence Thomas and Neil Gorsuch, 2017, in the Peruta versus California case, involving a carry issue just like we just saw in NYSERPA versus BRUEN. Now, that is where the view of Clarence Thomas was. Now, let us move forward to June of 2020. All right, we're going to put all this into context. You just heard what John Roberts wrote. You just heard what Clarence Thomas wrote in 2017. Let's go to June of 2020. What happened in June of 2020? Remember, that was an election year. In June of 2020, the Supreme Court issued their final decisions on cases that they were going to grant cert to, which means they're going to hear on the merits, and the cases they were going to deny cert to, which means cases that people wanted them to hear, but they say no to. In June of 2020, the U.S. Supreme Court denied cert in a case out of New Jersey. This case was a carriage case seeking to interpret the right to bear arms as meaning you have a right to carry a gun concealed under the Second Amendment. Sounds like NYSERPA versus BRUEN, right? Well, it was. It's basically the same as NYSERPA versus BRUEN, except the name of that case in June of 2020 was Rogers versus Grewell, which came out of New Jersey, challenging New Jersey May issue permitting scheme. Now, in June of 2020, when the Supreme Court denied cert in Rogers versus Grewell out of New Jersey, dealing with May issue permitting schemes, the same type we saw knocked down in NYSERPA versus BRUEN, there's 5 justices on that Supreme Court that are still on the court right now, among others. Ready? Neil Gorsuch, Clarence Thomas, Brett Kavanaugh, Sam Alito, who are already on the record for supporting the right to keep and bear arms in all respects. And the 5th judge was, of course, John Roberts. So I want you to keep those 5 names in mind. Gorsuch, Thomas, Kavanaugh, Alito, and John Roberts. They were 5 votes right there on the Supreme Court in June of 2020 when the Supreme Court denied cert in Rogers versus Grewell coming out of New Jersey. Yet what happens 2 years after that, in June of 2022? So in June of 2022, NYSERPA versus BRUEN is decided. You all know this. We've talked a lot about this case. This is a huge win for the Second Amendment that said that the right to bear arms means the right to carry a gun outside the home loaded for the purposes of self-defense, and that may issue permitting regimes that give discretion to government officials as to whether or not you're good enough to have a gun and not constitutional. Now, in NYSERPA versus BRUEN, it was a 6-3 decision. Who were the 6 justices in NYSERPA versus BRUEN that voted that the right to bear arms means the right to carry them? Well, that would be Neil Gorsuch, Clarence Thomas, Brett Kavanaugh, Sam Alito, Justice Amy Coney Barrett, and Chief Justice John Roberts. What is the difference between that list I just articulated and the list in Rogers versus Grewell? Well, what's interesting, of course, is that in Rogers, the Supreme Court obviously did not have the votes necessary to uphold the Second Amendment because someone on that court refused to go along with it, which did not give them the 5 votes they needed to support the Second Amendment's right to keep and bear arms. So who could that be? Well, if you look at who was on the court in June of 2020, we know it wasn't Gorsuch, Thomas, Kavanaugh, or Alito because they all have robustly been on the record of supporting robust Second Amendment rights. And it's John Roberts who sometimes has concerns, apparently, because he is obviously the 5th vote that did not vote to grant cert in Rogers versus Grewell, right? Or they didn't feel that he was the guaranteed 5th vote on the merits of the case. That was probably the concern as to why they didn't grant cert in June of 2020 in Rogers versus Grewell. We did not see cert granted in Rogers versus Grewell in 2020. And yet 2 years later, a mere 2 years later, we have a big win in BRUEN. The only thing that changed between June of 2020 and June of 2022 when it came to the makeup of the Supreme Court is that we replaced Ruth Bader Ginsburg, who passed away in September 2020, with Justice Amy Coney Barrett. And yet here we have in NYSERPA versus BRUEN a 6-3 victory with Gorsuch, Thomas, Kavanaugh, Alito, Barrett, and Roberts, right? 6 justices supporting the right to keep and bear arms. And yet 2 years earlier in Rogers, they wouldn't even grant cert. So what changed? Well, it's obviously what changed is that Chief Justice Roberts went from voting against the Second Amendment or not willing to support the Second Amendment in June of 2020, and then in June of 2022, he was one of the 6 justices that supported the Second Amendment in NYSERPA versus BRUEN. My question is, why didn't Justice Roberts support the Second Amendment in Rogers versus Grewell in June of 2020? Why did he wait to get that 6th vote of Amy Coney Barrett before he was willing to rule and come out in support of the right to keep and bear arms and properly defined. It wasn't a hard decision. It was pretty obvious what's going on. So obviously what happened here is, for whatever reason, that John Roberts, as I see it, this is my best speculative guess. I have no inside information, but this is my best guess. That Chief Justice John Roberts felt that he didn't want to be the deciding swing vote in June of 2020, which we would have been if he had granted cert in Rogers versus Grewell, which he should have done, in my opinion. But he didn't do that. Instead, he waits to come out publicly in support of the Second Amendment's right to keep and bear arms. 2 years later, when he's no longer the fifth swing vote, he was now the sixth vote, which meant his vote wasn't even necessary to win for the Second Amendment, because they already had 5 votes out of the 9 of the justices. So he was just icing on the cake to make it 6-3 as opposed to 5-4. Now, what does all this mean when it comes to your Second Amendment rights? And I think why this is all important, when you read what Chief Justice Roberts wrote just a few days ago, it's this. Andrew Breitbart once said that politics flows downstream from culture. Okay, I think I got that quote basically right. But the idea is that culture influences politics. So you have culture first and then politics second. Now, it seems to me that where Chief Justice John Roberts has written this robust defense of using really men and women with firearms. I mean, that's what he's not using the word guns here, but that's what he's really talking about, right? When he talks about all these services, the U.S. Marshal Services, the court security officers, the Federal Protective Services officers, the Supreme Court police officers and their partners, et cetera, he is talking about people with firearms protecting the lives of judges. That's what he's saying. So it seems to me that the reason why this is so important is that Chief Justice John Roberts has had a cultural mind shift in favor of the right to self-defense. He has recognized, perhaps finally, that, as Clarence Thomas put it in the Peruta case, that while judges have the benefits of all these federal protective services, the U.S. Marshals and all this 24/7 security at home, their families and the like, there is no doubt in my mind that these judges are human beings too. And they recognize that while they may be able to benefit from these protections from hoodlums, cycles, and criminals that may want to do them harm, ordinary Americans do not have that luxury that the judges do, which goes back to the discussion that Clarence Thomas had in the Peruta case, where he talks about, again, Clarence Thomas said, for those of us who work in marbled halls, guarded constantly by a vigilant and dedicated police force, the guarantees of the Second Amendment might seem antiquated and superfluous. That's what Thomas wrote in 2017, but it's pretty clear that Chief Justice Roberts, who's a very important institutionalist when it comes to the Supreme Court, has had a change of heart in terms of making sure that not only judges, but I think all Americans have the benefit of private or other types of guns for the purposes of self-defense. Because I can assure you, nothing focuses the mind about self-defense than being surrounded by individuals with guns that are protecting you, and then recognizing as you go to the store, as you go to a club, as you play golf, as you go to a ball game, whatever it is that you do, they must think to themselves, geez, what do all these other Americans do when it comes to their threats, when it comes to their dangers, when it comes to their lives? How do they protect themselves and their families when they don't have the benefits of being, working in marbled halls, constantly guarded by 24/7 federal, guaranteed service, federal government service? So I think that this letter, this report in December 2022 from Chief Justice John Roberts, talking about the physical security and thanking Congress and others for protecting the judges from violent threats, is a cultural shift, on the part of what I would say is the most reliable sixth vote in favor of the Second Amendment by Chief Justice John Roberts. So I am convinced that the Supreme Court, including Chief Justice Roberts, now fully understands and is completely committed to the importance of self-defense, because they've had to live it, unfortunately. But now they've seen it. I'm confident that going forward, when it comes to Second Amendment cases, you're going to continue to see a more and more robust defense of it in a way we hadn't seen in the past. Okay, I know this is kind of a longer, geeky video. I apologize for that, but it's important to understand how these things all get connected together. And if you haven't subscribed to the Four Boxes Diner, please do so, and we'll see you again soon. The Four Boxes Diner.
Orders up. Table 2A.